little girl with autism named Jess. It is also about the agency's failure to present any evidence to refute the testimony and evidence brought forward by appellant, which showed that ABA was effective and medically necessary treatment for Jessica's autism.
Isn't part of your argument that ABA treatment is in every case of autism?
We believe that it is the premier treatment for autism, yes, but specifically this case concerned Jessica and her need for this.
But under your argument, they could never say no to ABA treatment.
I believe that that's outside the scope of this argument. At the hearing below, Jessica's mother was actually told repeatedly this is not a covered benefit. By the time we got to the hearing, the agency apparently had switched positions and had said that if it was medically necessary for Jessica, then it would be provided. At the hearing below, they presented absolutely no testimony or evidence which would in any way undermine the effectiveness of ABA therapy or would cast any doubt on the effectiveness of ABA therapy. Rather, we presented evidence. Dr. John Bailey, who is the professor emeritus at FSU, who is the head of the ABA program, behavioral analysis program there, testified that this has been an effective treatment for autism for 25 years.
Well, is effectiveness is that what is required? Is that the finding that's required for Medicaid to cover the service, or is it medical necessity? And depending on what your answer is, I mean, are those two things synonymous?
They're not necessarily synonymous. However, in this case, we did have a number of medical professionals that recommended ABA therapy, that prescribed ABA therapy, that felt that this was the appropriate treatment for Ms. Elbaz. And of course, you know, medical necessity in some sense is a legal judgment, and they were making a clinical judgment. However, I think it is notable that the agency, in fact, I think it is the key here, that the agency did not present a single medical professional who could refute that testimony. Furthermore, we had evidence that not only was it appropriate therapy for Jessica, but that she had already benefited and that her symptoms were ameliorated by the few sessions that she was able to receive because her mother paid for them out of pocket. So I understand what you're asking. I think, again, that to look at the record in this case, there was ample evidence on the record from numerous experts that had said that this was appropriate, necessary treatment for Jessica, and frankly, deafening silence on the other side. They had the report of Dr. Burton Goldstein, who, as we just heard about hearsay testimony, he did not testify at the hearing. We simply had his report saying that he wasn't entirely certain of the diagnosis of autism and therefore couldn't determine whether or not ABA therapy was an appropriate treatment for Jessica. We did allow Jessica to go to Dr. Goldstein, who interviewed her and who examined her. Unfortunately, there seems to have been some miscommunication between Dr. Goldstein, who the agency recommended that we send Jessica to, and Jessica's mother, who's not a native English speaker. You can see on the record it's inaudible several times where she's testifying, unfortunately. We think there was some miscommunication, and unfortunately Dr. Goldstein gained the idea that ABA therapy was merely a reading program for Jessica. However, the applied behavioral analysis assessment that we submitted never references reading and merely speaks to the fact that the purpose of the service was to ameliorate the symptoms of autism that Jessica suffers from.
With respect to, I guess, many of Jessica's witnesses, there was some vigorous cross-examination, and aren't we required to defer to the trial court in terms of the weight, perhaps, that was given to that testimony in light of some of the cross-examination that was taking place?
Right. To some degree, I think that the trier of fact is always entitled to a certain amount of deference. However, I would argue that to give so much weight to the agency's experts so as to essentially turn a qualified maybe into a no is affording the agency's experts far too much weight, and it exceeds the bounds of what the trier of fact is in fact able to do. His determination must be based on competent and substantial evidence, and in this case, again, The testimony of Dr. Folstein, which I think it's important to note that the agency never actually asked Dr. Folstein, is this service medically necessary for Jessica? She did not answer that question under oath. And her report was ambiguous as far as the medical necessity of this treatment. And again, on the other side, we had numerous medical professionals who said that this was medically necessary, appropriate treatment. And so I think that in order to base this decision on competent and substantial evidence, you would have to first say, that we had, in fact, established competent and substantial evidence, and essentially the agency presented no evidence to rebut that. And therefore, the only conclusion in this case that can be based on competent and substantial evidence is to say that applied behavioral analysis was medically necessary for Jessica Alves. I think also it's important to note that even the agency itself does recognize that ABA is an effective treatment. It's sort of a bit of tragic irony that the very day that Jessica's mother finally received a written notice of denial that led to the hearing in this case, she also received an email clarifying that applied behavioral analysis is a covered service under the Kid Care Program, which is Title 21, which interestingly her older daughter is eligible for and does receive, that's a state health insurance program that is also funded by the federal government in part for families up to 200% of the poverty level. So it's sort of ironic that the older daughter who does not need applied behavioral analysis actually would have been eligible to receive it through Title 21, but because Jessica is entitled to Social Security income and therefore receives Title 19 Medicaid, the agency determined that she was ineligible to receive applied behavioral analysis. And additionally, to say that applied behavioral analysis is somehow less than effective treatment, as you're all aware, the Stephen A. Geller Act requires private health insurance companies in Florida to pay for applied behavioral analysis for their customers who have autism. And so I think that it's abundantly clear that the Florida legislature has recognized the effectiveness of this treatment and has endeavored to ensure that children in Florida are given access to this important treatment. It is quite literally one of the only treatments for autism, as is demonstrated in Jessica's case, and as was testified to on the record. She had received some of the more traditional, recognized, perhaps by the agency at least, treatments, including speech therapy, occupational therapy, drug therapy, and none of these therapies were effective for her. In fact, the drug therapy specifically was counterproductive in the sense that the side effects made her so drowsy that she actually fell asleep during school, but then during the periods when she wasn't asleep, she was actually still continuing to have outbursts and demonstrate socially inappropriate behavior that interfered with her ability to get an education and to interact appropriately in school. And those behaviors also persisted at home as her mother testified at the hearing. While the state clearly plays a role in determining which services will be considered medically necessary for children under the EPSDT program, I think the state must also have an obligation to bring forward some legitimate, articulable reason for overruling the decision of a treating physician. The EPSDT standard is that essentially it makes any optional service under Medicaid, it makes it mandatory for children under the EPSDT program. And I think it was clearly demonstrated at this hearing that not only did applied behavioral analysis have the potential to ameliorate the symptoms of Jessica's autism, including the behavioral outbursts, including the inability to follow even basic safety instructions as her mother testified, but it actually had done so in the few sessions that, again, her mother paid for out of pocket at great expense to herself. This is a family of extremely limited means. I think that it had been demonstrated that those few sessions that she had received had done more for her than any of the previous treatments that the agency had, in fact, paid for. And if for no other reason, I think that demonstrates that this therapy ameliorated the symptoms of her autism, and therefore the agency was under an obligation under EPSDT to ensure that she had access to it. Furthermore, the agency under EPSDT is actually required to make sure, they have an affirmative duty to make sure that children are screened for various disabilities and illnesses, and that their parents receive information about potential treatments. And I think it's very notable that over the many months that Jessica's mother attempted to access treatment for her daughter, she was repeatedly told, this is not a covered benefit, this is not a covered benefit. And then finally, we got close to the hearing, and it became an issue of whether it was medically necessary for Jessica. Well, that had never come up in the preceding months where she was seeking this treatment. The issue was merely, we don't care how medically necessary this is. It's not a covered benefit. It's not something that we will pay for Jessica. And then all of a sudden, she was told, okay, well, if it is, if you can prove to us that it's medically necessary, then we will, in fact, cover this. And now it would appear, at least from the briefs, that the agency has once again picked up the argument abandoned at the hearing level that this is not a covered benefit and would advance the notion that this is somehow experimental. Again, that's contrary to all the evidence that's on the record at the hearing level, which is what this is about today. So we would ask the court not to allow the appellee to prevail with this untimely argument, but to credit the uncontroverted testimony and evidence that was brought forward at the hearing and pronounce unequivocally that ABA therapy is a medically necessary treatment for autism for Jessica Alves, and as such, that the state is required under EPSDT to provide that service for Jessica.
Just real quickly in closing, there was significant briefing on the treating physician rule, and I'm concerned that that may not have been properly preserved for our review. If you disagree, could you elaborate on that?
Well, I do disagree. I think, again, as I attempted to distinguish in my brief, I think the treating physician rule very well may not apply in this context. I think there have been numerous cases since the Black and Decker case cited by appellee that indicate that the agency does have to give a certain amount of deference to the treating physician. But even if you are not willing to go that far as to say that there is a treating physician rule in this case, I think that you certainly can't say that the treating physician has no role in determining what is medically necessary for their patients. I think that would completely subvert the entire process. In fact, normally when a service is asked for, it's my understanding that a nurse reviewer actually determines whether or not the service will be granted until they decide that they can't, just on the basis of the physician, the treating physician, decide that the service will be approved. Then it gets sort of, if you will, kicked over to an agency physician to make that determination. And so here, because there was no agency physician that said absolutely the service is not medically necessary for Jessica, I think you have to look to her treating physician, who are all, several of them that testified, are in a good position to know what their patient needs and to prescribe it for them, and they endeavored to do so. And again, the agency did not have a single physician who in response said, no, this is not medically necessary. Thank you.
May it please the Court, my name is Tracy Cooper and I represent the Agency for Healthcare Administration. Your Honors, the DCF hearing officer determined in this case, based on competent and substantial evidence, that ABA therapy is not medically necessary for J.E. to treat her autism. As such, the final order should be affirmed. Medicaid cannot pay for a good or service unless it's medically necessary. Here there was testimony from a treating physician that the service was not medically necessary, and a report. And that treating physician was actually Dr. Goldstein. She hasn't been recognized, or not Dr. Goldstein, I'm sorry, Dr. Fulstein. She has not been recognized as such, but she spent an hour and a half with J.E. She talked to her, she talked to the mom, she took a medical history, and she observed the child, and she determined that the service was not necessary for the purpose that the mother was requesting it for, which was the reading. Now, regarding any miscommunication, if there was a miscommunication, it was brought forth by the mother. And, there's nothing that the agency can do about that. But I do think that Dr. Fulstein testified that she thought that the child was maybe a little bit below on her behavior and a little bit below in her speech, but the service wasn't necessary because she was also receiving occupational therapy, she was receiving speech therapy, she was receiving the drug therapy, she had a psychologist, or So she was receiving a lot of services from the agency, and this additional service wasn't medically necessary. It could have been helping her a little bit, and there does seem to be some evidence of that. But just because something's helping doesn't mean it's necessary.
Okay, so I just want to be clear. So Dr. Folstein, as opposed to Goldstein, right?
Yes,
Dr.
yes, there's a lot of
Folstein,
Steens.
She gave an opinion about medical necessity?
I believe she did.
In a broader context, not limited to what her understanding of her role to be, which was kind of an analysis as it relates to reading improvement?
She said it's not necessary for reading improvement, and then during cross-examination she was asked, did you observe her behavior? Did you observe these things? And she said yes, and they didn't seem that out of line for me. So I think she didn't actually say it's not medically necessary, but it's inferred that she wouldn't have authorized it for this child if it was her making the decision. And we're talking about an expert in autism here. She's a professor who specializes in psychiatry for the University of Miami, and she's a clinical professor, which means that she deals in ABA a lot, and she actually testified to that as well. So we're not talking about somebody who is less qualified than the experts that J.E. brought forth. Matter of fact, we're talking about somebody who's more qualified and who actually spent more time with this patient. If you look at the experts who testified in support of ABA therapy, one of them was Dr. Torsic, who said that she saw the patient during I can't remember if it was a well visit or a sick visit, but the mother informed her at that time that she was already receiving ABA therapy and she wanted a new prescription, so she wrote it. So she didn't really make any determination whatsoever. So the second one was a physician's assistant who had been seeing J.E. for a while, but what she actually testified that when she wrote the first prescription for ABA therapy, she'd never heard of the service before. That's almost bordering on malpractice. You're prescribing something you don't know what it is. The third one was Dr. Molina, and she's the psychiatrist. She is the treating psychiatrist, but there's no evidence in the record that she has seen the patient in the past 3 years. All we have is a prescription that was written after the fair hearing that says, I'd recommend behavioral therapy, specifically ABA. Behavioral therapy encompasses ABA, but it's not the only type of behavioral therapy that exists. So, we're talking about a lot of evidence on both sides, and the hearing officer determined that the agency's witnesses were more credible because they actually considered the definition of medical necessity that is required to be met in these Medicaid cases.
What about Dr. Bailey's testimony, which I believe was unrebutted, that ABA therapy is the most effective way to treat autism, and that ABA treatment is often the only treatment autistic children respond to?
He is an expert. He's not a medical doctor. He practices in ABA and he teaches it. I do believe he's got a good deal of experience, but he's not a medical doctor, and a medical doctor has to make the medical necessity determination under law. Your Honors, there is no set treating physician rule in Florida. The medical necessity inquiry is triggered by the prescription that's written by the doctor, so that is definitely taken into account. It is the thing that starts this inquiry, but then you have to actually look at the criteria in the rule, which is 59G 1.010 166C, and it's 166A, but 166C actually says the fact that a provider has prescribed, recommended, or approved medical or allied care, goods or services does not in itself make such good care or services medically necessary or a medical necessity or a covered service. So you have to look further than just the prescription. You have to look at all of the evidence. And that's what the hearing officer did here. And there was competent substantial evidence that supported his decision. and I think you should affirm for that reason.
What does not covered mean? Does not covered mean that it's not medically necessary, or does not covered mean you never pay for it no matter what?
Well, I think there's two different versions of not covered that we're talking about in this particular case, so I'm glad you brought that up. UMBH, which was the subcontractor who reviewed this case, does not have the authority to provide that specific service, to pre-authorize it, so in their sense it is definitely not covered. They can't provide it. That doesn't mean the agency as a whole will not pay for it if it's not medically necessary, if it is medically necessary for a particular child, but you have to go through that inquiry. Typically, ACA doesn't particularly like ABA, as you might have kind of guessed, and the reasons are it's not provided by a medical doctor, it's provided by somebody who may or may not have certification. It is very individualized. There's no specific set of care rules that you go through. There's no we're going to address this, and this in this order. It's just whatever the therapist feels like.
Is it ACA's position that ABA therapy would never be a covered benefit for autistic children, or that it's just not covered, it's not medically necessary in this case?
It's not medically necessary in this case.
So it could be covered. It could be a covered benefit.
It could be under the EPSDT. It wasn't under the behavioral health program, which was at issue here. UMBH only has to do with the behavioral health program. So there's a wider Medicaid program, and that's just a subset of it. So it wasn't covered under that program.
So are you suggesting that if this child sought this same service under EPSDT, that there is a greater likelihood that it would be provided?
No, I'm saying actually, Your Honor, that we did look at that when it came time for the hearing. We went from the behavioral health program to the EPSDT program as a whole.
So your position is it's just not medically necessary in this case, although you're not necessarily refuting that it might be beneficial. It doesn't cross the threshold of medical necessity.
Exactly, Your Honor.
And if it did, you would provide it.
Yes, Your Honor.
I guess what I'm hearing is that in order to prove medical necessity, this applicant would have had to present testimony from a psychiatrist, a medical doctor.
Your Honor, I can't tell you exactly what he would have had to, or what she would have had to show, because honestly it's up to the hearing officer to weigh the evidence, and he wasn't convinced by the evidence that was presented.
Well, I guess you made a statement earlier that medical necessity has to be testified to or attested to by a medical doctor.
Yes.
So I guess my question is, this child could have had an army's worth of psychologists and behavioral therapists come in and say, this is the best thing out there to treat this child's issue. But because there's not one psychiatrist who is a medical doctor, there's not one psychiatrist in that army of specialists, medical necessity is not proven.
Your Honor, you would never actually have that scenario, because you have to have a prescription from a medical doctor to start the inquiry.
So if the medical doctor then prescribed it and came in and testified this is medically necessary, she would have carried her burden.
Well, the hearing officer could have found that she carried her burden. You'd have to, again, it's a weighing of the evidence.
So in this case, the ALJ could have said ABA is approved. Based upon the testimony that the hearing officer had, the hearing officer could have authorized ABA treatment.
Yes, there's testimony on both sides.
If they were persuaded that it was medical necessity.
I think that that's not the inquiry in this case, though. The inquiry is there competent and substantial evidence to support the conclusion that he did reach? And the answer to that is yes.
But I mean, if he had said yes to ABA,
we'd provide it.
There would have been competent substantial evidence to support that. Now, as far as this competent substantial evidence, the child has the burden of proof, or the agency has the burden of proof? Who has the burden of proof?
It depends on if you're talking about an initial services request or a reduction of services. In an initial services request, the party requesting the services has the burden of proof.
That would be the child in this case?
Right. If you're talking about a reduction of services, say we were giving her 12 hours of ABA therapy and we said she can only have 6 now, then we'd have to carry the burden of proof that the reduction was supported by competent substantial evidence, was medically necessary. It has to do with there's some information about, parents taking care of their children, reduction of services over time, those kinds of things come into play. So sometimes services do get reduced, but in this case, the burden of proof was on JE. I think, Your Honors, another thing that you might want to look at is the Moore versus Reese case out of the 11th Circuit, and it talks about the treating physician rule and the fact that it's not a specific, you get a service because it's prescribed. It's an interplay between the agency and the prescribers, and there are reasons that the agency can limit services, and one of them is medical necessity. So it was proper for us to do that in this case. And if this Court has no more questions, I'd ask you to affirm.
Your Honors, I think that my opposing counsel said something very important just now. She said that Dr. Goldstein did not actually say that ABA therapy was not medically necessary for Jessica. Indeed, Dr. Goldstein did not say that ABA therapy is not medically necessary for Jessica. Furthermore, she also stated that by law, the medical necessity determination must be made by a physician. In this case, Healy Gilbert, who is a physician's assistant, who is a licensed practitioner of the healing arts practice within the scope of her practice under state law, prescribed ABA therapy. Dr. Tarasik, although maybe it was a short appointment, she did prescribe ABA therapy. Obviously, in her clinical determination, this was a medically necessary service. Indeed, Dr. Marino Molina also recommended ABA therapy and must have thought in their clinical judgment that this was a medical service that Jessica needed.
But as a broader proposition, the fact that a treatment or something like that or a procedure is prescribed by a physician doesn't necessarily mean that it's medically necessary for purposes of Medicaid, right?
No, it does not. And again, if the agency had come forward with a physician who had said this is absolutely not medically necessary and here's why, then I would say that there might have been competent and substantial evidence to determine.
But if it was your burden of proof, I mean, they don't have to come forward with any evidence if it's your burden of proof, do they?
It's our contention that we bore our burden of proof, and then in response, because the rule is that the medical necessity determination has to be by law made by a physician, they would have had to have had at least one physician who said on the record, or even had in a report said this is not medically necessary, and they simply did not carry that burden. Therefore, the only competent and substantial evidence in this case leads to the conclusion that the service was medically necessary for Jessica.
Thank you, counsel. That concludes our docket for today, and the court will stand in recess.